you all for coming to our most recent afternoon program on the rise of antitrust scrutiny of big tech, transatlantic perspectives. Delighted to have you here. It's a nice event because of transatlantic perspectives. We're honored to have two very distinguished speakers. One is well known to people here at Penn. Herb Hovenkamp is the James Dinan professor, who's basically is a university professor here. For those of you who don't know, among other things, he co-authors the leading antitrust treatise. There's a famous, there's two things that I was struck by. One, they're in the process of putting together a Festschrift for him. If those of you who don't know what that means, it's when a lot of people write tributes to someone, and all of us wonder if we'll ever become distinguished enough for people to write tributes about us. Most of us, that's not going to be the case. But the famous quote that you see, I'll refer to a lot, is, you would rather have a paragraph of the Arita and Hovenkamp treatise on your side than 4 members of the Supreme Court and 3 courts of appeals. And it's a tribute that it's not 5 members of the Supreme Court, because then you could overrule them. We don't get to get that far, but it's extremely influential. So obviously, he is been called the Dean of the American Antitrust Scholars, and we're delighted to have him here today. The transatlantic part of the perspectives comes from Professor Thomas Fetzer. Professor Fetzer is the chair of public law, regulation, and taxation, where he was also at the University of Mannheim Law School, where he was also, God help him, dean of the School of Law and Economics and chair of the Department of Law. He has since been paroled from his sentence as dean, where he did a lot of great, wonderful things. But he's also the academic director of the Mannheim Center for Competition and Innovation, and also academic director of the Leibniz Science Campus Mannheim Taxation, where he collaborates with, among other things, our own Professor Michael Knoll. So he has a wonderful set of ties. He's co-taught here with us at Penn many times, including a joint seminar, which was one of our more memorable teaching occasions, and we're delighted to have both of them here to explore what has become an extremely important and pressing topic. So I thought I'd kick things off with you, Professor Fetzer, which is, we've seen recently, before we can get to the enforcement actions, a number of very high-profile studies looking at big tech and antitrust. We have something called the Furman Report out of the UK, a joint study of EU scholars, the Digital Platforms Inquiry in Australia, and in the University of Chicago, the Staegler Center issued a major report. Anything we learned from these, and any surprises?
Well, first of all, thank you for having me here. It's really a great pleasure and honor speaking with such distinguished experts of U.S. antitrust law. So, coming to the reports, I mainly will focus on the European ones. So that would be one commissioned by the European Commission by Commissioner Vestager, who is responsible for competition law. There is a German one, and the German one and the European one are partially authored by the same persons. The Furman report, since 2 weeks, I can't really call it a European report anymore, so it's a UK report.
And Furman's an American.
And Furman's an American, so it's a weird report. So I will mainly focus on that, but my biggest surprise to start with that, frankly, comes from the Staegler report from Chicago. Because what you would assume is, since the companies that we are talking about very much when we talk about digital platforms are US companies, so Facebook, Google, Amazon, and the like. And at least in Europe, we think that US antitrust law is very much reluctant in intervening into markets. My big surprise is that this report suggests or recommends many measures which even I would consider to be far-reaching in terms of how willing they are to intervene into digital markets. And that concerns the diversity of content aspect as much as access to data and so on and so forth. So that's my biggest surprise. What we learned, or what I learned from them, well...
the German report is the best.
Yeah, the German report is the best. Of course I'm biased here, because one of the authors of this report is a co-author of mine, so that's one thing. The German report, as you might not be surprised being a German report, to me is the most structured one in a way. The European report, and I said this in my class, is to me a collection of anecdotes and observations, and I don't really know where they want to go with that. But what all reports share, and I think that's one thing that we will discuss for sure more intensely over this class here or over the session here, they point out that there are some things going on, that I want to leave it that vague, in digital markets that we potentially should be worried about when it comes to competition and protecting competition. And even when I applied the US approach, more focused on consumer welfare, which potentially are harmful to consumer welfare, and we need to understand them better. The one frustration that I have with most of the reports, and that should be my last sentence for this initial remark, is even though German law professors don't pay too much attention to empirics, it would be nice to have more than just anecdotes, but to have some empirical evidence for the measures that are suggested there. I understand these are new markets, and so it's hard to get data, and but even taking that into consideration, I'm sometimes, by all reports, surprised how willing they are to intervene into markets based on assumptions what could be and what can't be. Again, I understand that there's maybe not enough good data out there, and there's always the fear if you wait too long until the point that you have the data, it might be too late because the market might be so, or the market structure might be so firm that you can't change it anymore, or at least easily. But still, it's a lot of, I can imagine that something bad happens, so let's something do about it. And that worries me to a certain extent.
Well, it's interesting. So one of the big venues in international competition law is called the International Competition Network. All the enforcement authorities get together from all over the world. And I actually got to be a speaker at a program at the last one on big data. And there was very much a sense of ready, fire, aim. That they really were primed to act without clear theories, clear evidence, and there is a huge move going that direction. It'll be very interesting. I've actually been invited to go back as a non-governmental advisor again this year. It'll be in Los Angeles at UCLA. And it's very curious to see the tone. The European report, the Australian report, just so you know how this works, it becomes highly politicized. So two things. One, there was a stalemate in the Australian Senate on a matter completely unrelated to competition law. And there was one independent senator. They needed his vote to pass this. His condition of his vote was to launch the digital platforms inquiry, even though the commission had initially decided against it. Why? The chairman of the ACCC, that's their regulator, went to high school with this guy. And if you want to see how reality happens, he wanted this inquiry, and he's trying to set himself up as the great advocate for this kind of intervention. And he's written a report that is kind of interesting in two ways. One is they combined it also with an industrial policy inquiry about how to preserve traditional newspapers. So guess what happens when you combine industrial policy with competition policy? Industrial policy is about promoting certain companies, and competition policy is about helping consumers. This is not generally a good idea, to combine two fundamentally different inquiries together. My running joke is it's the only thing that's ever turned Rupert Murdoch into a hero in Australia. I mean, they're used to banging on him as the competition law problem, but there it is. And the other thing that's kind of interesting about it is the report consistently says we need new regulatory authority. Now, they invited me to come speak at their annual conference, and it's really interesting. What we need more regulatory authority really means is we cannot actually bring and win a competition law case under existing law. Because if they could, they would. And so there's a bunch of things about market definition I could go into, but there is a very, you see these things happen in very interesting sorts of ways. Herbert, did you want to add anything?
Yeah, a couple of things, mainly about the Staegler report. George Staegler, most of you are probably too young to know him, was a paradigm Chicago School economist, won the Nobel Prize, did his formative work in the 40s, 50s, and 60s. And the Staegler Center was formed around that collection. I think it's fair to say that the Chicago school has very largely absconded from the University of Chicago, certainly from the law school, but it's moved on to other places, like George Mason, for example. And the Staegler report is remarkable. I looked at it briefly this afternoon. Its chair is Fiona Scott Morton from Yale. She's an industrial organization economist. And I would characterize her as just about as far left as you can get in I.O. today and still proclaim with a straight face that you're a neoclassical economist. She's very interventionist, not somebody that George Staegler would have selected. And remarkably, the report talks about the political power of the big platforms as an antitrust problem, which is something that's been anathema on antitrust for years, where concern is always focused on economic power. I think it's fair to say that from all directions, including these reports, everybody agrees that there's a problem with the platforms. What there seems to be very little agreement about is exactly how to go about solving it, and whether we can do so within existing legislation or whether we need something new.
So Herb, while I've got you talking, what we're going to, there's two obvious places to start, one in the US and one in Europe. The second one we'll talk about, Europe has actually brought initial judgment in 3 cases against Google totaling about $9 billion. We'll talk about them from big to small, but right now, somewhat to the surprise of many of us, there are ongoing investigations by US antitrust authorities, by the Federal Trade Commission and the US Department of Justice, at a time under a Republican administration, which most people expect would be a time of fairly non-interventionist policy. Any insight into what's going on or how you think this is going to play out?
I'll offer some predictions. Yes, out of the 5 major platforms, 4, excluding Microsoft, are being investigated by the 2 antitrust agencies. Why Microsoft was excluded? Well, the best guess is that we already put them through the ringer at the turn of the century, just about 20 years ago now, and a very large set of cases brought by the Justice Department. And so maybe from this point on, they're off the hook. But Google, Facebook, Apple, and Amazon are all currently under investigation. The agencies do not discuss ongoing investigations. They won't answer any questions about what they're finding or what the likelihood will be. They will either announce at some future point that they're going to take some kind of action, or else it'll just kind of evaporate and go away. My prediction is that number one, they will not offer any significant recommendation for structural relief, that is breakup relief, with one exception, and that is they may suggest that we re-examine mergers that have involved small high-tech firms that have been acquired by the hundreds by the major platforms. The platforms are buying up techs left and right. Every one of them started out, in someone's garage, and they know that the way you get to be a big tech is you survive, innovate, and grow. And one way of preventing new competition from emerging is to buy small companies up before they have a chance to do that. The problem is we don't have good merger standards today for going after small techs. Number one, if you look at the conventional structural indicators we use for mergers, they're too small. Most of them are just too small to go after. Secondly, many of them are not competitors with the platforms that are acquiring them. Many of them produce complements. And we generally think acquisitions of complements are good things because that brings together 2 things that customers can use both of them. So one hard question is whether we can have an effective policy against platform acquisitions of startups without new legislation. Now, let me hasten to add that the statute would authorize it. The statute's very broad. It simply says where the effect may be substantially to lessen competition. But the problem is that we've had so much restrictive case law and judicial and enforcement interpretation by the agencies that we've constrained the meaning of that term. So it may take new legislation for us to get that. What I do think is more likely to come out of these investigations are ad hoc injunctions or cease and desist orders in the case of the FTC against specific contract practices, exclusionary deals with advertisers, most favored nation clauses. That's where a company insists on better terms than other competitors are getting, perhaps some tying, fairly harsh deals that Amazon makes with some of its third-party sellers and so on. But this is basically plain old-fashioned meat and potatoes antitrust. Getting injunctions against contracts is something that goes on every single day in the antitrust world. So there's not going to be a lot of excitement in that, but that's what I think the agencies are most likely to find.
So the FTC is talking about breakups. Is that unusual?
Breakup of recently merged firms. It's unusual but not unheard of. The government has, historically, the government always went after mergers after they occurred. And then in the mid-'70s, we passed this statute, the Hart-Scott-Rodino Act, that requires pre-merger notification. And since then, it's become the general practice to try to attack mergers before they occur because the social cost of unwinding them can be so high. But there's nothing in the statute, nothing in the Hart-Scott-Rodino Act that forbids the government from going after consummated mergers, and it still continues to do so once in a while. Those kinds of breakups are a little bit different than the much more aggressive breakups that you see proposed by some presidential candidates, for example, because they usually involve the spin-off of a firm that has not been totally integrated into the acquiring company yet, depending on how long ago the acquisition occurred. So it simply means unwinding a relatively recent transaction, but that's certainly a possibility.
So I'm interested in these, to talk one more thing about the U.S., these little small firms. If we're going to bar the acquisitions by the large platforms, we've attempted to regulate certain things like this in the past and have discovered that sometimes they backfire. That is, essentially you're telling a small entrepreneur, you're essentially taking their market that could have been develop their own company, go and do their own initial public offering, or allow them to be acquired. And one of the big changes that's happened in Silicon Valley is certainly before the dot-com bubble burst in '99 and to some degree afterwards, their ambition was to do IPO. Their now ambition is to be acquired. I mean, they're not actually looking to be a standalone company, and they may not have all the complementary resources or whatever. And the worry is by blocking that, you're actually going to hurt innovation because these companies who could do A or B can only do A. Is this a concern?
I don't think it's a legitimate concern. I mean, acquired companies have two sets of values. They have integration value and they have exclusion value. And the message of the antitrust laws is that you can value integration but not exclusion. So for example, if Facebook wants to acquire WhatsApp, that's a transaction that actually occurred 5 or 6 years ago, and what Facebook wants is the improved text messaging and phone and other services that WhatsApp offered, more power to them. That's a good thing. That means that Facebook is improved. If what Facebook really wants is to be able to exclude other people from developing a messaging platform, messaging capability, and WhatsApp would be an avenue towards that, they're not entitled to do that. As Christopher suggested, it's unquestionably true that the market value of a fair number of acquired firms will go down if they cannot be acquired. But you know, Hewlett-Packard, Amazon, all started out as companies not with the intention of being acquired, but with the intention of developing themselves into a competitive source. And for them, it worked.
Netflix, modern examples, Uber, they're all standalone companies that are doing pretty well.
I mean, Bill Gates started out as the sole licensor to IBM for a computer operating system, at that point in time called MS-DOS. I can count about 4 people in this room. Oh, you remember? Oh, okay. Well, MS-DOS was the Microsoft DOS, Microsoft Disk Operating System. That's what it stood for. And that was Bill Gates' contribution to IBM's technology. And he built on that, and of course, Microsoft is what it is today.
And IBM is essentially dead. It's a patent holding company. They don't really do anything, but it was fascinating. Fairly early in the game, they tried to reclaim this by releasing an operating system called OS2 and failed miserably, and it's gone signed to the dustbin of history. So, Professor Fetzer, I want to bring you back to you. Let's talk about Europe for a minute. So let's talk about the politics of Margaret Vestager. So this is fascinating. So those of you who don't know, one of the things is there are 27 member states of the EU. And they have these things, you think of them as, we call them executive departments, or ministries, they call them director generals. And one of the odd things is there are always going to be the same number of directorate generals as you have EU states, because the politics of this means that every single one has to have one. And she was the commissioner for competition, and they're nominated by the home government, so you have to be usually a member of that party. The then Commissioner Vestager's party lost that election, yet she's still in the leadership of the EU in a different capacity. Can you help us understand what happened around that change? Because she is regarded as one of the most popular people in Europe, because she's taking on the big US tech companies and winning. She's one of the few that's able to do this. I had a lot of friends who said this would never happen, and here we are. What happened?
I mean, there are several things. First of all, Ms. Vestager, she still is also under the new commission responsible for competition. She is also responsible for digitalization, but she is one of the few commissioners who has actually kept her position, even though the ruling government in Denmark is not governed by her party. I think what most people believed, and what also Ursula von der Leyen, who is the president of the commission, believes, is that she has done a pretty good job over the last couple of years. So sometimes, and you might disagree with Ms. Vestager on several points, but sometimes the quality of your work seems to matter whether you get a job or not. And I think from a European point of view, that's not the worst news, right? So if it's not just to which party you belong and what role your country plays in Europe. So I think I think it was due to the quality of her work. And so that's one thing. The other thing, she has made it pretty clear from the very beginning of her membership to the EU Commission that cleaning up digital markets is going to be her landmark thing that she wants to do. And frankly, many competition law scholars, but also politicians, are worried about what they see when they look at digital markets. And I want to make that clear here, even though it's hard to prove counterfactuals. I don't necessarily think that Europeans are so worried that we are only looking at US tech companies there, and that Ms. Vestager is going only after US tech companies. I tend to say in my class, you know what, there are no European tech companies that you could go after. So if you think there is a problem, these are pretty much the only companies that you could go after. I mean, there will be some Chinese ones in the future when they enter the European market, but if you are talking about B2C, right? So there is no Google, there is no Facebook, there is no Amazon, and so on and so forth. Having said that, would the enforcement be the same if we had some European companies? I don't know. right? So clearly there's also industry policy dimension to that. So why are Europeans or many people worried if it's not because these are US companies and there are no European companies competing with them? I think what you have to understand is that EU competition law has always been very much concerned about protecting competition as such. And consumer welfare plays an important role because we think consumer welfare is going to be protected by competition as such. But that means that even if we see situations where consumer welfare arguably is great, but we see a structural problem in competition, or we see that producer welfare or surplus might be diminished, we are much more willing to intervene than other jurisdictions would do so. If you look at that from that angle, what we see is in many platform markets, highly concentrated markets, right? So, and that's not a surprise, right? Because due to economic effects, we will oftentimes have winner-takes-it-all markets. So there is one Facebook for social networks, and there's in Europe, Google is much more dominant in the search engine market, and so on and so forth. And if you see such monopolistic structures, and they don't change that much. I totally subscribe to your examples with IBM being challenged by Microsoft, and we have seen this in Europe in the past too. So there was a social network called StudiVZ, which we will never have heard of because it was only targeted to the European market or to the German market, which was by far dominant, and Facebook took over. So we see some change, but we see very stable market shares for example, Google search in Europe. To my big surprise, that's very different in the US. I always wonder why Google search is much weaker here in the US as compared to the European markets. But if you see such structures, you start to wonder how much competition is actually happening there. If you only look to consumer welfare, you would say, well, that's great. You don't have to pay for these services. I mean, there's no monetary price. You pay some personal information, and that creates a totally different set of problems. You have wonderful choice, you get all those new services, so what's the problem? If you think that competition as such should be protected, you get suspicious that there potentially is some problem. And we also had these cases with most favored nation clauses in hotel booking platforms, and we have the Google cases which we thought to be problematic. And so if you ask why Ms. Vestager is so successful, I think because many competition lawyers will share the impression that there are potential problems. She is willing to take up those problems, to do something, and I think that contributed to the fact that she not only was the commissioner during the last commission, but also during this commission. Again, I'm not saying I share all her views. But to me, it's not a surprise that she still is in office.
So one of the interesting things is Google is the dominant search engine in almost everywhere in the world. And the four countries that immediately come to mind where it's not: China, Japan, Russia, and Korea. But interestingly, in each of those markets, it's not that they're competitive. There's a different search engine that is dominant in each of those markets. So for example, in China, it's Baidu. In Japan, it's Yahoo, Bibi. I can't remember the name of the Russian ones. And Korea is really interesting. It was dominated by one search engine called Naver. And it was encountered competition from another search engine called Daum, and Daum didn't compete evenly with Naver. It displaced it. And I'm trying to figure out what do we make of this? In the sense is if there seems to be something structurally that makes them tend towards one survivor, what does that mean for competition law? Well, Herb, how would you handle this?
Well, I would handle it first and foremost by observing consumer behavior and begin with the premise that, number one, when you're talking about search engines, there is no lock-in. That was a big issue in the Microsoft case. The only way you could switch browsers was by switching operating systems, and the only way you could switch operating systems was by switching computers. And so the cost of switching was so high that gave Microsoft a very considerable advantage. Well, we are living in a completely different world today. You can have, if you want to have six, I've got 6 search engines on my iPhone.
You do?
Yeah, I do, and I
Is
use
it
several of them.
interesting, or-
Well, they're for different reasons. One of them is very low bandwidth, or when you have a weak signal. One of them has no memory, so if you want to search for something and you don't want anybody else to know what you were searching for, thank you very much, I'm not going to say. I have a search engine for that, and then I have the usual suspects like Mozilla and Google. But you can switch back and forth freely. They're all free to acquire. You can do the same thing on your desktop. You can have as many search engines as you want. So what accounts for Google's favored position? Well, number one, I don't think it's discrimination in results, because to the extent discrimination in results harm consumers, they would use a different one. I mean, the idea that Google will give us favored YouTube videos because Google owns YouTube, rather than some other video that we would prefer but we don't get because Google is favoring YouTube, or that Google won't give us the best airline rates. Those arguments don't make a lot of sense in a world in which you can costlessly and instantaneously shift from one search engine to another. So if Google were persistently supplying inferior search results, I don't think it would be capable of maintaining its market share. I think habit accounts for some of it. We get used to a certain set of instructions, doing something a certain way, although it's not obvious to me that they are all that different from one another. But it's very much a competitive ball game. But fundamentally, I'll just say this, and I'll shut up about this subject. Unless you have a good and anti-competitive theory about why Google does so well in the search engine market, given the ease of switching back and forth, I think it's foolhardy to intervene. We'd be much more likely to make the problem worse rather than better.
Well, it's fascinating too. You can see examples, for example, in browsers where we used to have it. I mean, Internet Explorer was the dominant browser. And now clearly Chrome, if you believe the numbers, has displaced it. And so you do see markets where install base hasn't meant very much. And as you point out, in browsers, I have multiple browsers on my computer all the time. So we multi-home them. And that quality eliminates the winner-take-all quality of a lot of markets. So there's a tendency to say all digital markets are winner-take-all. I think, Professor Fetzer, you brought an excellent example. Are travel sites a winner-take-all market? The existing evidence suggests no. I mean, there's multiple ones who do, and they've changed over time. And understand, instead of just looking at digital markets and saying they're bad, this seems to be a bad idea.
Let me give you an even stronger example. Dating sites. And what's the key there? Well, the key is product differentiation.
Yeah.
One of the problems with search engines is it's not that easy to differentiate them. You search, you can have some differences, but why is it that we've got, I don't know, dozens of dating sites available, even though their databases have very considerable? Wouldn't we be better off if we had one giant dating site and everybody could meet everyone else? And the answer is no. We want filters. So if you're Jewish, you might want to go to JDate or Christian Mingle if you're Protestant, or depending on your level of promiscuity, you might want to pick a more aggressive dating site. I was Match.com, which tells you something about me.
Not FarmersOnly.com?
Pardon?
Not Farmers Only, you're from Iowa.
Oh, I never even tried it. But product differentiation is a big part of the game.
Well, it's interesting. I'm married 26 years now, but my brother was recently divorced, so I'll tell you how I came about my information. And it's fairly clear there's a difference between Tinder and eHarmony, and people understand it and they sort. But you're open the door. Let's talk about the comparison shopping case. I can't resist. So you're talking about differentiation. And what that tells you is, is there competition here? One of the issues, you said there's very little competition to Google in search and it's hard to differentiate. One of the questions is the distinction between what we call horizontal search and vertical search. So horizontal search is what we all think of as Google or Bing, a general search engine where you just put in any term and it gives you anything. Vertical search is going to Yelp and searching for restaurants, or going to where I go kayak and searching for travel, or going to Amazon and searching for books. And one of the things that the comparison shopping case against Google, which led to a $2.5 billion fine, I think, or roughly, said those are different markets. Does that make sense? And for example, the motivating example in the complaint brought by the EU was about backpacks. And they said, type in backpack into Google, it's going to give you Google's comparison shopping sites as the primary result. There are other comparison shopping sites. The big complainer in this field is probably Etsy. And they said, this is favoring Google's comparison shopping sites over everyone else. Is that, when we're trying to define the market for that, how should we be thinking about that, and what are the questions we should be asking?
I mean, I would like to first comment on one of the things that you just said, Herbert. I'm sometimes surprised, even though we are all using the same products, and people here shouldn't be that different from people in Germany and other European countries. I'm surprised how different it's used then in practice. So when you were talking about dating sites, actually in Germany there's only one major dating site left. Right? So there are two. I mean, there's
What an outrage!
There's Tinder out there, but for the major dating sites there were 3 and they merged to 1. So we have a highly concentrated market.
Well, merger to monopoly is a whole different matter.
Yeah, I mean, the problem is that the Federal Cartel Office faced a very difficult situation because it was clear that 1 or 2 out of those 3 would go bankrupt anyway. And that's a classical problem that you face, or failing firm. How do you deal with that? And so arguably, there was not much that it could do about it. The search engine market is highly, I mean, if you just look at the numbers of customers, it's highly much more concentrated. 90% of all searches in Germany are done through Google. So yes, Google's argument, the competitor is just one click away, is true. But as a matter of fact, in Europe, the situation seems to be much different. And yes, not every market is a winner-takes-it-all market, but for reasons I do not completely understand, in Europe, those markets tend to be very, very stable and very concentrated, unlike in other markets. So even though we are living in a globalized world, I think it's worth paying attention to those differences. I don't have a good explanation to that. So to the question, how do you define the market for search engines? I mean, what it ultimately comes down to is probably demand-side substitution, as we have always done that, and that's probably an empirical question, and I don't have good numbers. I only can add anecdotal evidence, which is no good evidence. I actually use those search engines differently. So if I'm looking for a hotel, I will never go to Google, but to Booking.com or something like that, or TripAdvisor. If I'm looking for something that I want to buy, I will go to Amazon and so on and so forth. Assuming that I'm not, to a certain extent, the average customer, and again, I don't have numbers, but I'm sure the European Commission did that and didn't just rely on what they believe, whether this is not. But to me, demand-side substitutability is really... it's not a surprise. I mean, it always has been important to define markets. And if customers use different search engines for different purposes, to a way, I would say those decisions were not so surprising to me. They're very consistent with what the European Commission has always done, and you might criticize them for that. But in a way, it's not that different from the original Microsoft cases, right? So leveraging market power would be the argument here, and tying products together in order to create barriers to entry that others have to overcome and cannot easily overcome. And that's true for the Google Shopping case. So there the argument would be leveraging market power from general search to specialized search. It's true for the Android case. So yeah, it's consistent with the enforcement.
So what's fascinating to me is you suggest something which I think is right, which is how we think about this should be determined by consumer behavior, what they regard as substitutes. And what always struck me is you end up with Google having an 80 to 90% market share. But you do it by defining the markets in a particular way. And to me, the backpack is a good example. They actually defined eBay and Amazon as being outside the search market because they're vertical search, not general search or horizontal search. But in the motivating example they gave, which is backpacks, the question is empirically, if you're actually looking for a backpack, will you type the word Google in backpack, or will you go to a merchandise site, like an eBay or an Amazon? And that's the empirical question which I think lays at the bottom of all this. And if you include Amazon and eBay in the market, Google's market share in comparison shopping dwindles quite low. It's only when you define it so that they're not in it that it really has a huge impact. And so this is why this is so critical. Now, with the other big case, this is $2.5 billion. Let's talk about the $5 billion case, which is Android. I know, Herb, you have ideas about market definition in the Android case, because they're saying Android, much like the Google search engine, has, what is it, about 80% market share in Europe? Something like that. And they brought a case against them, against their practices. Herb, you mentioned when we were talking about this earlier, you thought that you had some comments about how to define markets in Android.
Well, the Android case is a challenge to various restrictions that Google owns Android. It purchased Android at least 15 or so years ago, and it's now an open source operating system for smartphones. They and Apple are far and away the two largest in the world. Microsoft is barely clinging on, along with a couple of other tiny firms, but for the most part it's Android and Google. They have radically different business models. Apple is the most closed of the computer systems. If you want to run the Apple OS, you can only do it on an Apple device. If you want to own an Apple device, you can only run an Apple OS on it. It's a very closed up system, unless Apple decides to license out or permit licensing in of some alternative technology. So for example, you can get Google search on Apple by Apple's choice. But for the most part, it's a closed system. Android is, as an open source system, means number one, it's free. The kernel, the basic code, is free. Any smartphone maker who wants can be a licensee at no charge. You can also make changes to it to accommodate your own hardware or consumer needs. You can't charge money for the changes. And there's a committee that's kind of in charge of maintaining compatibility across different manufacturers. But it's an open source system. And Google is kind of at the top of this. It licenses Android out. It obtains no revenue from Android. However, it has some very lucrative restrictions on the Android system. One of which is that for sales or licensing of apps, they have to be done through Google Play, which is the Google Store, basically, kind of the equivalent of the Apple Store on the iPhone. For most phones, Google Search is the default search engine, and of course Google Search picks up revenue from advertising. It's only the default. And this is a big difference between US and EU policy. In the US, we think of tying as something that happens when you are required to take a second product as a condition of getting a first product. And tying law in the US has always been relatively clear that persuasion, convincing, nothing counts as tying unless it's a pretty strong requirement. A default, as a result, under US law does not meet the requirement for tying. It simply means that what a default means is when you get your phone, it will have Google search on it, but if you want to download any one of a number of other search engines, you're free to do so. So, you know, it's a case that exposes some fairly important differences between U.S. and EU approaches and explains why the U.S. is more conservative and less interventionist when it comes to the big platforms. One thing
Because in the EU, a default is enough to constitute a tie, is what you're saying.
yeah, well, it's enough to constitute competitive harm.
Okay.
That's right. One thing that occurred in the Android case, was that the Commission defined the market as the Android operating system and excluded the Apple OS, the Apple operating system. So in other words, it said Android and Apple are not in the same market. That has been sharply criticized by U.S. antitrust scholars, particularly those that are more conservative. Now, I'll just start out with a premise here, stated it to some of you in class, and that is, in the presence of product differentiation, market definitions are always wrong. If you put Android and Apple in the same market, we end up treating them as perfect competitors and we simply add up their market shares. That clearly is not the case. They are very different operating systems. They're incompatible with hardware choices. People have very strong preferences for one over the other. So to say they're perfect competitors is wrong. However, to go to the other extreme and say they don't compete at all, which is the result you get if you put them in separate markets, that's wrong as well. They clearly do compete. And some people, cell phones we usually speak of as single homing, which means most people own only one at a time. Most people don't have both an Android phone and an Apple phone. You might switch when your subscription is up. You might switch back and forth, but you only own one at a time. So your opportunities for switching are infrequent. The thing is today, and this is an area where U.S. law is ahead of EU law, today there are much better ways of measuring market power that do not require a market definition. And that's by measuring elasticities of demand directly by looking at output responses to price changes. Now, one of the difficulties of these so-called direct measurements is that they're very sensitive to the quality and amount of data. But the thing is, in these markets, everything is digitized. We have a record of every transaction since the beginning of time in these markets. And as a result, using direct measurement is not all that hard. I believe it to be the case that if you use direct measurement, you would discover that each Android and the Apple OS have fairly significant market power because each of them faces at best only limited competition from the other one. So I tend to be with the EU on the question of whether Android has enough power. Now on this other issue, which is use of defaults in order to steer people. Now they're not always defaults. I think device makers are required to have Google Play, right? So that's an absolute tie. If you're running Android and you're making a Samsung, for example, and you're making a phone, Google Play has to be on your screen as a choice for software, for apps. And of course, then Google Play may have a certain amount of discrimination as to what it offers. There are solutions to that problem that don't require major thing. One thing you could do is require the cell phone companies to accommodate multiple stores. I mean, we're going through exactly the same thing with Apple. We had an important Supreme Court decision just a year ago, Apple versus Pepper, and the basis of it is the fact that the Apple Store is the only avenue you can use if you own an iPhone to purchase apps. And then Apple takes a 30% cut of any app that costs money. And that was the basis of that complaint. So one thing we could do is loosen up the mechanisms by which people acquire apps and programs. And for example, Apple could be ordered to carry Google Play in addition, or a version of Google Play in addition to the Apple Store, and and vice versa. Those are relatively modest remedies, but they're ones that could promise to be somewhat effective.
So it's interesting, a couple things you said. One is we don't have two phones. What struck me is when I travel internationally, there are countries where that's the norm. And in fact, it's typical where they'll have a work phone and a personal phone and they won't mix. And my father, when he worked for the federal government with security clearances, would never do that. It's a really interesting thing to see that goes on.
Yeah, ask Hillary Clinton.
Yeah. Well, that's I'm not going there. I promise you that. But the other thing is kind of interesting. Just to clarify one thing, to quibble with one thing you said. It is actually not required to use Android that you have Play Store. There's sort of 3 levels of commitment in the Android world. You can just use Android. It's open source. You can, actually there's 4 levels. You can use the public testing tools to show it's compatible without signing anything, in which case you're free to do whatever you want. You can sign something called the Anti-Fragmentation Agreement, which actually requires you to have a search capability on your phone, but it doesn't have to be Google's. Or you can sign what's called the MADA, the Mobile Application Development Agreement. And if you sign the MADA, you are required to have the Play Store. And so there is sort of a menu of options. The bigger question is, what is the economic impact of those? And are people, if they're all essentially compelled to sign the most restrictive one, that's a problem. What's interesting is,
Consumer?
no, it's the operating system developer who's licensing it. And Amazon created Fire OS by going back, and they don't sign the MADA. On the other hand, Samsung has been working on an operating system called Tizen for years because they're all worried about being under the thumb of Google. And I think they're a good 10 plus years in, they still don't have a product because it's hard. And so there's an ambiguity here, which it is hard. And Google does seem to be making some contribution, which is good for consumers. On the other hand, they've got these other practices, which many people that go beyond their contribution, which other people interpret as sharp. And what we're struggling with is to separate the good from the bad and have legal doctrines that do that.
I think if you ask people at Google, they would say the license they originally gave to Amazon was probably a mistake. Yeah. But they did. And Amazon, which of course is an extremely big licensee, all of the Kindle Fire and other reading devices, if they have some version of an Android operating system on it, but they're kind of their own special thing. But they have that by virtue of the fact that they negotiated an individual license quite some time ago.
Well, it's interesting. There's a handful of these that are not actually Android, and they're not that widely distributed. So what do you make of this? I mean, the funny thing is, yes, they exist and people are doing it. They're not as successful. And it's one of these things we have to sort out. This is one of the challenges of antitrust law. As an example of the acquisitions, when Google acquired Android, they had 10 employees and no revenue. And so is that the kind of classic early acquisition we should walk? This is sort of the questions we're going to have to confront as we go down this path. And I asked that question also. I don't know the answer to that question. But it's really quite interesting.
Probably 1% or fewer of acquired tech startups would ever realistically turn into a major platform. I mean, there are hundreds of them. By the way, Wikipedia maintains lists, search, companies acquired by Amazon, companies acquired by Facebook, and then the lists are themselves rankable. You can click on revenue and they're ranked by purchase price. You can click on date and they're ranked by the date of acquisition. So you get a good picture. And they number, in the aggregate, it could be as many as 1,000 companies that the big platforms have acquired. But if 2 or 3 of those 1,000 had turned into similar platforms on their own, we would have a much more competitive market structure today than the one that we actually have. And so that raises a legal problem, is the standard of proof and the due process requirements for going after an acquisition because, there's a 1 in 1,000 chance that this guy might turn into a rival at some future point. We just don't know who it is. And should we be permitting or prohibiting acquisitions on that basis?
Well, I'm going to get an opening for Professor Fetzer to throw his views in, but in addition, I wanted to put on the table something that I know is going on in Germany, which is a pending amendment to the German Act that's going to take a very different approach to platforms. That's quite new. And so I don't know if you have any thoughts on our previous discussion, or if, feel free to change the subject as well, because this is a development in Europe that, frankly, I had no idea about until we spoke.
I mean, maybe some thoughts on what you were just talking about in the Google Android case. I'm not sure. I think either it was Professor Yoo or Professor Hovenkamp through his book. So the first time that I got in touch with US antitrust law, I think one of the first lessons was that you win or lose cases in market definition, because the broader you define the market, the less likely it is that you're going to have market power, and once you have established a market and when you have established market power, it's hard for the company who has been accused of abusing its market power to win, and that's probably even more true in Europe than it is actually in the US. With the market definition in the Google case, I mean, they said, well, there is a market for operating systems that you can get a license, and there's a market for operating systems where you can't get a license, and I would totally agree to a certain extent those two compete with each other, and to a certain extent people who are in the Apple world will not switch to the Android world for several reasons. To me, it's going to be interesting, and it's more a remark than actually. To me, it's going to be interesting. There's been a new case being started by a complaint of Spotify against Apple. Spotify complaining against Apple that they restrict the communication between Spotify's customers and Spotify, so you have to go through the Spotify channel to the Apple store if you want to communicate with Spotify. Spotify needs to use the payment system of Apple, and since Apple Music is directly competing with Spotify, this might be a problem. So there might be some leveraging involved there. To me, the interesting question is, does the EU Commission, if it wants to be consistent now, has to say Apple is its own market? Because otherwise the Android decision doesn't make too much sense. You can't say Android is a separate market and then you investigate Apple and you would say, well, there's one market for operating systems, so Apple is not dominant. So that's one thing. With the tying, I mean, it depends on which level you think, if it's only a default rule or it's really tying, and I think you mentioned that the smartphone manufacturers, for them I think it's tying for those who use the iOS, because if they're the Android system, if they want to use Android, they have to install the Play Store, as a matter of fact, because if you buy a Huawei phone these days where you can't download the Play Store for other reasons, nobody's buying an Android phone where you don't have the Play Store, right? So that's a factual thing. But then, and that was the requirement of Android or of Google, if you download the Play Store, you need to have the search app and you need to have the Chrome browser. So I think this would not only be a default rule, that would be a time for the customers that they can switch, right? So they can go to another search engine, and so there are two different layers to that. So these are just two comments to that discussion. To the German discussion.
I want to take a quick poll. How many people here have switched from an Android phone to an Apple phone, or an Apple phone to an Android phone?
And those in my class have to say now what they told me. None.
None. I'm just curious. So it happens, but it's apparently not very common.
It was a mistake.
It was a mistake. That's part of it too.
Did you leave Apple?
But then is it hard to switch back?
Yeah, which is why I haven't.
Interesting. Sorry.
No. I was asking the same question in my class. I mean,
this is the audience participation part of our presentation.
Again, this might be a biased sample group, but nevertheless.
Well, actually, the number of Apple users and university students is actually much higher than it is in the larger population. It just is.
But Apple's for rich kids.
Yeah, that is the reality of it. Not that
you go out to Iowa, you'll find more Android users.
I'm not sure our students feel particularly rich when they're charging them what we're doing at the moment, but I understand all that.
The flip phone looks good.
It isn't a matter of switching. There are Apple people and there are Android people.
Well, it's interesting. I was an Apple person until I graduated from law school and worked for a firm. And what I discovered is none of the law firms I was recruiting with actually supported Apple devices. And so I was an Apple user from the 80s.
BlackBerry was the
I'm
only thing
surprised you
happening
didn't
back
quit.
then.
Damn. It's just a machine to me. Anyway, sorry, Professor Fetzer.
Well, I mean, we could talk long about Apple and what they're doing, whether they're a separate market. So what's going on in Germany? I mean, one of the results of the German report is that there has been an amendment proposed to the German Act against restraints of competition, basically introducing something new, and I have to admit I have not completely understood the concept. I think I understood it to a certain extent. And the idea is that, I mean, German and competition law, as any competition law, usually, if it comes to unilateral behavior, requires some kind of market power, right? So that you then can abuse. One of the problems is that many of the platforms that we are talking about are active in arguably several different markets. If you want to define that, and I understand that's less important in US antitrust law. And so it's hard to establish where they actually do have market power. But let's think about Facebook, who is doing text communication services and Instagram and all that stuff, or Google and so on and so forth. And what the German legislator now will introduce, and I have no doubt that this is going to become the law with the next amendment to the Act, is something which is called intermediation power. Intermediation power meaning those platforms are bottlenecks to get access to hotels if it's a booking platform, and for the hotels they're a bottleneck to get access to potential customers. So they control this. So it's not about competition on the level of those platforms. So is there a second hotel booking platform or something like that? It's more, does this platform exercise control over access to customers and to hotels, right? And if a platform, so the Federal Cartel Office now has to make a decision whether whether a platform has intermediation power. And if you go through the legislative materials, it's clear intermediation power doesn't equal market power. So it's a new concept, and that's the point where I said I don't really understand what's going on there. Intermediation power, there's a definition in the law saying, if a platform has cross-market relevance, if it has access to data, if it controls access to input markets, to output, and so on and so forth, the Federal Cartel Office can make a decision to say platform A has intermediation power without any direct consequences. And then the second step would be that the Bundeskartellamt, the Federal Cartel Office, would say, well, we impose certain obligations on that platform. So one would be prohibition of self-preferencing. So this is one of the big challenges that we see many hybrid platforms which are not only neutral platforms but are also active in another market. There would be the Bundeskartellamt could impose an obligation to give access to data. There could be an obligation for those platforms having intermediation power to separate their data sources. So, and if you go through the legislative material, the example would be, for example, Facebook must not combine the data of its WhatsApp customers with the data of its Instagram customers with the data of its social network sites, because the argument is this raises barriers to entry for others because access to data is a competitive advantage and so on and so forth. So the point where I said, which to a certain extent I'm troubled, is so to me it seems that the legislator thinks, well, there is a problem, we don't really know what it is, but we are sure there is a problem, so we should do something about it. That's basically what the law says. And I think that's just because you think that there is a problem, that if I was one of the investigated companies, that would be a little bit too little for me to be really convinced that this is going into the right direction. The other two things are, in a way, that's the first step to regulating platforms. Right? So by regulation, I mean you impose ex-ante obligations. Competition law or antitrust law, as we all know, is also a kind of regulation, but it has a different perspective. This is the first step to regulating these platforms, which I'm skeptical with is really a good step. And this argument is, you can't separate it from the one that I just made, is so far we assume if there is an abuse of market power, we should do something about it. So order the companies to stop their behavior and change their behavior for the future and maybe pay damages or whatsoever. Under the new law, the Federal Cartel Office doesn't have to establish any abusive behavior. Right? So the only thing that they have to establish is that this company has intermediation power. Right? And to me, that's a tremendous shift in how we treat platforms. And again, that's a kind of platform regulation, even if it will be in the competition law, part of competition law.
Well, that would be a big change for the U.S. as well. So we have other things we could talk about, but I want to reserve some time for questions from the audience. But before we do that, I can't help but go back to a topic that Professor Hovenkamp, you opened up, which is the views of the current presidential candidates. This is something on a lot of people's minds and much more abstract with respect to big tech and antitrust. What's your view?
Well, I think most of the Democratic presidential candidates believe, or at least have articulated, some kind of need for antitrust reform. The moderates, much less so. The two most outspoken proponents of reform are Klobuchar and Warren. Klobuchar principally through a revised merger statute. It's an actual bill. It's been proposed, updated a couple of times. It would condemn mergers simply on the basis of aggregate size, and would reach a lot more mergers than we are currently doing without any real requirement that you would be able to predict a higher price or lower output, which is what we currently require merger law to do. So it's kind of an attack on bigness per se. The Elizabeth Warren proposal is also relatively specific, but it's not a bill yet, as far as I know. It's targeted at Amazon, and it would separate Amazon's internal self-production business, which is substantial, from Amazon's third-party business, and require Amazon to either exit from one market or the other, or require it to have two separate websites. Okay, now, I'll just give you a couple of examples where that would have some real bite. Amazon makes, or has made for it, a whole bunch of products under the trade name Amazon Basics. Batteries, alkaline batteries, plain old AAA batteries like you put in a flashlight or something. You can get an Amazon Basics brand. You can also get them on the Amazon website from Rayovac, Duracell and other companies that sell batteries. Amazon Basics makes small kitchen appliances like toasters, which compete with Black & Decker. You can go right on down the line. Oh, they make Post-it notes and rubber bands in competition with 3M. Just a couple of observations to be made about this. Number one, these are not small firms. These little firms. Duracell is owned by Berkshire Hathaway, which is not a small firm. Black & Decker is the biggest domestic manufacturer of small kitchen appliances, and 3M is the biggest domestic manufacturer of office supplies. So whatever we're doing in this case is we're not protecting small firms. Furthermore, where the Amazon Basics product is available and you can see them on the same website, so you're looking at the same website, you punch in AAA batteries, you'll see Duracells and they'll cost $8 for a pack, and then you'll see Amazon Basics and they'll cost maybe $6 for an equivalent pack. And you go right through the list, you generally find the Amazon Basics price is a little bit lower. What Amazon is doing in that case is it's forcing the prices down of pretty large firms, not as big as Amazon, but pretty large firms that traditionally have pretty high margins. In fact, that's where Amazon enters. That's a rational interest. Yeah, if you want to develop a new product, you want to look for a lot of sales at relatively high margins, and so that's what you look at, okay? I think this platform separation idea is one that Elizabeth Warren has to forget, because what's going to happen is there's going to be less pricing pressure on both of the two platforms. So the price of the name brands is going to go up, but the price of the Amazon Basics brand is going to go up as well. Consumers are going to be harmed, and it's hard to identify anybody who's going to be benefited other than these manufacturers, and these manufacturers are not little single store, family-owned operations. I will vote for Elizabeth Warren if she's the nominee, but I do hope she loses that particular item from her platform.
For those of you who don't know, if you look at the top 10 firms by market capitalization, six of them are U.S. tech firms. 2 of them are Chinese tech firms. And this is not the case of a decade ago. And one of them is Berkshire Hathaway. So it's just the way it is. At that point, I'd like to open this up to questions from the audience in the time we have left. It's funny, I know they're always shy about the first question, but I know the people in this room, I don't normally count you among the shy and reticent about passing up an opportunity to ask a distinguished panel like this. Don't make me call it. Yeah, Caroline.
Why, Elizabeth Warren, what reason is she articulating for wanting to separate?
She's kind of fallen in with this kind of lefty group of antitrusters called the neo-Brandeisians. They kind of want to roll the clock back to a time when we were much more protective of small businesses and much less protective of consumers. The thing is, with this particular proposal, I don't think it protects either small business or consumers. I think it's just a bad idea. And she's made it front and center of her antitrust platform. Now, the Klobuchar proposal for more aggressive merger enforcement has a certain kind of populist appeal. This idea, if we can just kind of go through the economy with a machete and chop a bunch of big firms into little pieces, that's a kind of a populist impulse. But we've learned from pretty bitter experience that rarely makes the world a better place.
Well, I have 5 more topics to talk about, which we discussed, so I don't have to open to the audience. I do want to give
Please
you the
don't.
opportunity.
Please ask a question.
Please.
Can you talk about how you see courts using increasingly sophisticated data to define markets and market power, and where you see them drawing a line? Like, are they going to draw a line at Rob and I, who are both white women who work at Edward Hamilton, or is there going to be
They're
something?
going to do exactly what we do in other technically complicated areas, including patent law, medical malpractice, and so on, which is, and this is what I think should happen. Antitrust experts are subjected to Daubert evidentiary standards, which means that their reports, once they're hired, they have to write a report, maybe give testimony, and that is all subjected to motion in limine if either the methodology or the applicability of the methodology is insufficient. You are right, that has produced a fair amount of squawking from federal judges that they're not really trained in all of these specialty areas, but that's why we appoint smart people to be federal judges, so they can listen to the two sides and decide whether this expert testimony meets the standard and ought to be included. Now, if you're telling me that's not a perfect system, I totally agree with you, but at least we would be asking the right set of questions.
So I have a slightly different answer that's not inconsistent, but would add something else, which is we may stop defining markets altogether if the data is good enough. We used to say we want to see if this is hurting consumers, which is usually an increase in price or a decrease in quantity, but we can't measure that. So we did something called the structured conduct performance paradigm, which is you look at market structures that tend to create bad conduct, and we infer that that structure leads to bad performance in the market. But this was always a second best. If we could get the direct evidence of the actual behavior, go there. What you start to see in actual cases is direct measurement of price effects. And in fact, if you look at the revised horizontal merger guidelines released in 2010, they say, if you can show direct price effects, skip market definition, which is always, as Professor Fetzer says, is a huge fight. And in the AT&T Time Warner merger, we had this structural model on the one side, and on the other side, Dennis Carlton put out regressions of the last 4 similar mergers and showed an effect. Or the blockbuster Hollywood video merger, they said if they're in line of sight, prices are 20% lower. And when you see that, they said, we don't need to define markets, we don't need to create a model of pricing behavior, we have a direct evidence of effect. And so what I suspect may happen is it puts a lower emphasis on that, and the nature of proof in these cases may change.
I mean, there's one point when we are talking about price effects. If it comes to digital markets, there oftentimes is no monetary price. So looking at price effects, I understand that, but might not be the perfect solution for those markets too, right?
Well, but okay, that's a two-sided market. These companies are making money someplace. And the classic example to me, to go back to old broadcast television in the pre-cable days when there was only advertising support, and we normally analyze those markets based on whether they could raise prices to the advertisers, because that's what's generating the business. You're not going to do better than free on the consumer side, and so the harm will ultimately be someplace else. We had a major case, the first major case in the Supreme Court went down 5-4, called Amex versus Ohio versus Amex. I will say without that, Professor Hovenkamp signed an amicus brief on one side of the issue. I signed an amicus brief on the other side of the issue. I will not tell you who was on the winning side, the losing side. Just say this is a very close and highly contentious issue. We're going to learn a lot more about this space as we go forward.
Yeah, and one important thing to keep in mind, this is not a problem that's unique to antitrust in any way. If you become a medical malpractice tort lawyer, you are going to be using forensic pathologists or cardiovascular surgeons or whatever particular tort you're involved in. If you're doing products liabilities under the third restatement, then you have to talk about engineering and design defects. Or if you're doing patent law, you're going to confront a lot of issues in which there is technical evidence that the judge probably does not fully understand, and Daubert is designed to act as kind of a screen. We also have a lot of jury trials in all 3 of those areas. And you know, we try to improve that technique as we go along, but antitrust is just one of the areas in which judges have to get sensitive to what's admissible and what's not with respect to expert testimony.
Something as mundane as a car crash. Those little insurance boxes which you can plug in, well heck, your phone GPS actually, when you look at the mapping functions, they report your speed. And there's all these functions that we can actually extract a lot of information from. That's part of the new digital environment we're able to, on a forensic basis, it's much more complicated, and we're going to have to accommodate. Please.
I was just going to say, do you have any opinions on the sort of emphasis that is being brought to price elasticity of demand really being the test and looking at just the data and not looking at demand-side substitution in certain markets that really aren't driven, but the competition just really is not driven, at least primarily by price, or to the extent it is, it's incredibly complicated.
Well, that's actually where we think this kind of data are most valuable, because we can rank products by how close they are in product space, right? So if you're a sporting goods store or a big box store, and the price of Nikes goes up by a certain amount, that's going to register in your electronic cash register, and you're going to find that there's a 20% shortfall in Nike sales as a result of this price increase. You find out that 2/3 of those go to Adidas, 1/3 goes to New Balance, and I'm going to run out of thirds here pretty soon. But the important point is that we can group. Today we've got data that can actually rank the closeness or remoteness of substitution by asking the very simple question, where do customers turn when the price of their first choice goes up? And this is what we do all the time in merger cases in the United States. It depends on good quality data. But the thing is about these platforms is we've got pretty good quality data. And so we can take large numbers of those observations and come in with pretty good conclusions about, number one, who the best placed competitors are, and second, how close they really are. And that gives us a direct mechanisms, because market power, measured by maximizing price cost margins, is simply nothing more than the obverse of the price elasticity of demand facing that firm. So we can measure power that way, and it's more useful to the extent that it doesn't have this binary quality that market definition. Because market definition, when we're looking at Nike and New Balance, for example, we got two choices. New Balance is in the market, which means they're perfect competitors, or it's out of the market, which means they don't compete at all. Both of those are incorrect.
And this is where you've been a leader in this, talking about quality competition as opposed to just price competition. I always think about, there's a if you just take one dimension, let's say for cars, safety or sportiness, then you're actually only competing with adjacent competitors. And it's actually a very limited form, even when you allow that. They have a tool called factor analysis, which is in a really nice paper that I like, that actually abstracts from people's behavior in purchasing markets. How many dimensions do people really think about cars? Whether it's economy and sportiness and safety and actually the answer under this paper is 6. And that actually increases the number of adjacent competitors you have on all 6 dimensions, where you're not that competitive here, let's say, on sportiness, but in some other ways you're actually disciplined a lot more. And it creates a much more complicated, but a much more robust space that tells us a lot more about what's actually helping and hurting consumers. And this is going to challenge our judges' ability to digest this data, but I think it actually has the potential to give us a lot more insight into what's actually good for consumers, which is what usually the goal. To date, until the neo-Brandeisian debate actually changes things, has been the goal for competition law.
Let me add one thing to this, and that is federal judges have the authority today to hire experts for the courts. They don't do it very often.
Why not?
They don't do it very often. Well, first of all, it's expensive. But if a judge says, okay, I'm lost in this particular situation, they go through the same process that parties do when they're selecting an arbitrator. They'll ask each side to come up with a list, and then they'll look for names that are common to both lists. The court will select an expert to look at the conflict and get a third party to come in and advise the court on what the right choice is. It can be done. But like I say, there's always been some federal resistance to
Well, there's one prominent case in the Microsoft antitrust case in the DC courts. They actually hired Larry Lessig to be an outside expert. He committed reversible error within a week.
Yeah.
So, I mean, the problem...
economist.
Yeah, and not just that, but even just a lawyer. I mean, just because we're law professors, the finer parts of practice, he actually engaged in ex parte communication without noticing of both sides. He's just talking.
Yeah.
You can't do that.
I encounter that problem a lot, and I don't see the judges asking for the parties' input. I see them just appointing like people from the firm that they worked for before, or that the economists that they used when they were in practice before they became a judge. And
My favorite moment is Richard Posner liked to sit as a district judge, just to keep it, thinking that he'll round himself out. And in jury selection, he committed structural error or reversible error immediately. Someone asked in voir dire about a person's profession, which is something you're entitled by law to ask. He says, oh, don't ask him that, it'll embarrass him. And so now the counsel is sitting there saying, we have to go through this whole thing, and whoever loses is guaranteed to win on appeal and be sent back. What are you going to do? I mean, it really is a lousy position to be in. And in fact, I think they settled it because it just wasn't worth, they see the cost, it just wasn't worth it. We're at time. I'm going to give it to Professor Fetzer, Professor Hovenkamp for any final thoughts.
Nope, I'm done.
Professor Fetzer?
We should have this discussion on a regular basis to see where politics is going, which direction after your election, after elections in Germany. It's always hard to predict the future, as we all know.
Well, I think that's a date.
And it's going to be interesting how, and that's part of the exercise today, how different those things will be treated in the U.S. or under U.S. antitrust law and EU competition laws. So I hope we can do this in the future again and see what we predicted today became true or not.
So you're all my witnesses. You just heard Professor Fetzer commit to coming back after our election to have this conversation again. And we look forward to it very much. Please join me in thanking them for a wonderful